SJC-13686, Massachusetts Insurance Insolvency Fund versus Workers' Compensation Trust Fund.
Okay, Attorney Mullen, whenever you're ready.
Morning, Chief Justice Budd, Associate Justices. May it please the Court, Kurt Mullen on behalf of the Massachusetts Insurers Insolvency Fund. The legislature created the Insolvency Fund to pay covered claims when an insurer covered by Chapter 175D, its Enabling Act, is declared to be insolvent. So when an insurer is declared to be insolvent, the fund steps into the shoes and pays claims that arise out of or are within the coverage of an insurance policy. The claim that we're here before you today involve cost of living adjustments that are required to be paid by Section 34B of the Workers' Compensation Act. That requires insurers to pay COLA to certain categories of claimants, and that is what the Insolvency Fund does. It doesn't do that because it's an insurer as defined under Chapter 152. It does that because under its own Enabling Act, Chapter 175D, Section 5(1)B says that the Insolvency Fund is deemed the insurer with respect to its obligations on the covered claims, and to that extent has all the insolvent insurer's rights, duties, and obligations. So here we have the Insolvency Fund paying COLA. Now, Section 34B requires COLA to be paid regardless of the date of injury. But for certain dates of injury, it also gives insurers a right, and that is to receive reimbursement from the Workers' Compensation Trust Fund. So, because the fund is deemed the insurer, the Insolvency Fund is deemed the insurer with the obligation to pay, it also has the right to receive reimbursement. The trust fund disagrees with that, and so we're here before the court on stipulated facts on two issues. And the Insolvency Fund is asking, first, that the court determined that the Insolvency Fund is deemed the insurer not just with the duty and obligation to pay COLA claims, but also with the right, where the statute 34B permits, to receive reimbursement.
Can I ask you a question about the reimbursement of COLA piece? This is a test case, and there's a universe of, I forget how many other people involved, 80, 90, I forget, something like that. Are those 89 or 90 people, whatever the number is that the entire universe of claimants to which this issue applies?
It's the entire universe that existed when we filed the claim, Your Honor, and the way that COLA...
Is it a diminishing number?
Diminishing number, and I'll tell you why. It's because Section 34B, subsection C, requires insurers to pay COLA where an employee is completely and totally incapacitated as a result of the injury, or to the dependents where the employee is killed as a result of, dies as a result of the workplace injury. The reimbursement provision only applies to a subset of those cases, and it's either injuries that occurred before October 1st of 1986, and then the legislature, subsection C, says, and to the extent that there's an increase in the average weekly wage above 5%.
That part is not, that part can keep getting bigger, right?
It can't.
Why not? Explain that to me.
Because in 1991, the legislature overhauled Chapter 152, and among the provisions they added to the COLA provision in subsection A of 34B is to say that the average weekly wage will never increase more than 5%. So the universe of claims here relates to injuries that effectively...
Before October 1986?
It's actually, if you look at the increase above 5%, it's December 23rd of 1991.
Okay.
But this is when the Insolvency Fund initially made its claim, it was 86 or so claimants. There have been insolvencies that have increased and decreased that number. But the long-term trend, because unfortunately no one lives forever, is that these claims have diminished over time I cite in our brief, we're down, as of the time the stipulated facts ended, we were down in the 40s. The insolvency fund has continued to submit claims, and that number will, over time, decline.
I don't mean to cut you off. Go
No, so I just want to thank you very much. I just have one more question. So that means that at the current time, for the post-19 December 31st or 23rd, whatever the date was, 1991 claims, the insurers remain obligated to pay COLA, but they do not get reimbursed for the COLA.
That's correct.
Okay, so I got it. Thank you.
So your opponent's going to get up and sort of talk about the fact that you're not continuing to support the workers' comp trust fund. But I'm confused by that, and I'm going to ask him the same questions. But the workers' comp trust fund is paid entirely by employers, right? The insurers are just sort of conduits of money, right? They don't, because there are different parts of the workers' comp trust fund, right? Like the workers' comp trust fund, do those pay for the employers who didn't buy insurance too? Does that?
The trust fund covers a variety of claims. We're here before you on COLA claims,
I
but
get
also
it.
there's Section 37 claims, a second injury
I'm just trying
claim,
to-
or if an employer didn't get insurance, as Your Honor
I'm
stated.
trying to make sure I understand. Their argument is somehow that you shouldn't get paid, even though you're paying the benefits, because you're not contributing to the system, but it's not your financial obligation to contribute, right? It all is paid for by employers and not insurers, right?
That's exactly right. The way that the trust fund is, for lack of a better word, funded, is that an assessment base is determined, there's an assessment rate. That is collected from employers who either purchase workers' compensation insurance or are self-insured or belong to a self-insurance group. The employers are the ones who pay the money for the trust fund.
The self-insured employers contribute to the fund?
No.
They can unless they opt out. So there's a...
Yeah, well, yeah.
Right.
Right. So, I'm sorry, I should have been more specific. You know this area obviously more than I do, so the self-insurers, employers who opt out don't contribute to the fund.
That's right.
Right.
And so
the same is true with the groups.
that's right.
Okay. Who
And
opt out.
Who opt out, right.
And then consequently, they don't get to get reimbursed because they don't contribute and they can't get reimbursed. But here, and by the way, this plaintiff is still paying into the insurance company currently covering this employer. This employer still exists, right?
That's correct.
And this employer has a new insurance company that's paying into this fund, correct?
Presumably that's the case, yes, because that's what they have to do.
So there's not this pay problem. I'm mystified by this, so.
You're not the only one, respectfully, Your Honor, and that's the issue that we've come into is that the trust fund, the way it is structured, is that it is funded by current employers who participate in the system. And if you purchase workers' compensation insurance, you have to participate in the system. And insurers, as you pointed out, collect those assessments and they submit them to the trust fund. My client doesn't issue insurance policies because it comes into play when an insurer has been deemed insolvent. So it doesn't contribute assessments or collect them, but because it doesn't have insureds from whom to collect them. So the way that the trust fund system is set up is that it's insurers who pay for it or self-insurers or self-insurance groups who participate in the system. Now, the legislature has put into Section 65, and this repeats itself in the COLA statute 34B and the second injury fund statute, Section 37, that there are certain categories of people who are self-insurers, self-insurance groups, or municipalities. They can opt out of the trust fund system. They can think it's not a good deal for them for whatever reason.
They're opting out of the workers' comp system in many ways, right? They're self-insuring and paying they don't have an insurance company, right?
They don't have an insurance company, but they still have obligations under Chapter 152.
I know they have to pay their employees benefits, but they're sort of doing it on their own without the insurance company's involvement, right?
That's correct. They're self-insured. I understand the Department of Industrial Accidents has to certify them as such. They may have to put up collateral. But they're not getting an insurance policy for their primary obligations here.
I mean, the 1991 amendments were dealing with a crisis. I remember it. So, but the DIA seems to be concerned about the integrity of the workers' comp trust fund. And they don't like money going out of it that isn't going back in it, but this isn't that. Right.
And I don't see it that, and I agree with you, Your Honor. This is the way that the trust fund is structured is that employers pay in. There are certain types of claims that the trust fund has to pay out, and COLA for certain dates of injuries are one of them, and there are certain other categories as well. But the way that Section 65 of the Workers' Compensation Act is structured is that employers fund that. That's the system, and that's on an ongoing basis.
And for the deadbeat employers, the other employers have to pick up for them, not the insurance companies, right? It's the other employers that step in.
That's correct.
Because again, a lot of employers don't pay or manipulate the workers' compensation system. That's the purpose of the workers' comp trust fund, right?
That is one of the purposes, and then the Workers' Compensation Trust Fund can go and chase those recalcitrant employers and get money. But it's employers who fund the trust fund. It's self-sustaining, and because of that, the Insolvency Fund has no obligation to. It has the obligation to pay COLA, but it doesn't have the obligation to pay assessments. And what the reviewing board has put in here is this extra step that you have to get money out of the trust fund. You also have to be collecting trust fund assessments from insureds and submitting them to the trust fund. But that's not the way the statute is written. There's no obligation that you have to do that.
You're making it more difficult for them to administer the fund, right? Because they turn to the insurance companies because there's a limited number of insurance companies versus thousands and thousands of employers, right? So if you're not cooperating, the system doesn't work as smoothly, or you're not in the system, right? I take it that's the reasoning.
It's fair to say you're not in the system, and the trust fund's position is you're not in the system, so you can't get money out of it. But we are paying.
Can you address their first statutory argument that it only covers the insurance policies and it doesn't cover the statutory requirements of COLA? Because that's not in the insurance policy itself. Do you want to address that?
I do. It's a little bit of a confusing argument to me, Your Honor, because we came on stipulated facts. We didn't submit policies, but this is clearly something that Insolvency Fund's obligation is to pay covered claims which arise out of and are within the coverage of an insurance policy. So whether it's within the coverage of an insurance policy or it arises out of coverage, and workers' compensation is statutory. It's a statutory creature. There are many things that are different about workers' compensation claims as a whole than our other property and casualty lines. The Insolvency Fund has that obligation to pay it because it's deemed the insurer under its own enabling act. And this, the court doesn't need to defer to the reviewing board because it involves the interpretation of Chapter 175D, and the statutory language is unambiguous. But this isn't something that the reviewing board got really hung up on. They assumed that the Insolvency Fund was deemed the insurer for purposes of paying this, and they had this extra statutory requirement that you have to continue to write policies, which we disagree with, because the alpha and the omega of who is exempted or who is barred from recovering from the trust fund are self-insurers, self-insurance groups, and municipalities that opt out of the system. And it's clear the legislative intent there is that if you are required to put into the trust fund and you opt out, then you can't come back later, you can't get your own recovery here. The legislature was very clear about that. And that's not, of course, the case that we have here. The Insolvency Fund is paying COLA claims. We are administering them. It's a diminishing pool of claimants for whom we are required to seek or we're entitled to seek reimbursement, and that's where we are. And when you look at the structure and certainly the intent of the Workers' Compensation Act is to have that funded by employers. And if you look at Chapter 175D, which is the Insolvency Funds Enabling Act, it's a limited safety net. It provides rights and obligations. We're here, we issue other, we list out other ones in our brief of the protections that the legislature has put in. But one of the protections is that the insolvency fund has the right to recover money. And that ultimately, because the entire insurance buying public funds the insolvency fund, that protects the insurance buying public. And so all we're asking for here in this case is the reimbursement to which the legislature provided that insurers, or those who are deemed the insurers, are required to provide. Nothing more, nothing less. And we ask that you reverse the reviewing board's decision.
Okay,
Thank
thank
you.
you. Okay, Attorney Jay Kumar. He's teed it all up for you.
I'm sorry, Your Honor?
He's teed it up for you. You get your chance to tell us why he's wrong.
Thank you, Madam Chief Justice. May it please the Court. Arjun J. Kumar, Assistant Attorney General, on behalf of the Department of Industrial Accidents and the Workers' Compensation Trust Fund. This Court should affirm the reviewing board for two reasons. First, the Insolvency Fund is not an insurer, and only insurers as defined by Chapter
But
152.
it steps, I mean, it's clear it steps into the role of the insurer. The language, I don't know how much clearer can that language be? I just, it just says that they step into that position. So explain to me how you draw this contractual versus statutory distinction.
Certainly, Your Honor.
Because they're the ones paying this. They've stepped into the defunct insurer. That's why they're paying the COLA benefits.
Well, Your Honor, I would note that Chapter 152, Section 34B and 65 don't entitle a payor to reimbursement. They entitle an insurer to reimbursement. To get to your question, Your Honor, about
And they step into the position of the insurer.
Right, in fact, the statute says they're deemed the insurer.
And Justice Wendland, Justice Kafker, I would note that Chapter 175D has its own definition of the term insurer that MIF also concededly does not meet, but it is also distinct from General Laws Chapter 152's definition. The way you might look at it is to say, Chapter 152 defines an insurer as X.
But it doesn't say MIF is deemed the insurer under Chapter 175D. It says MIF is deemed the insurer to the extent of its obligations on the covered claims and shall have all rights, duties, and obligations of the insolvent insurer to such extent. So it's pretty specific that it's not, we are an insurer, as that term is defined in 175D. It's we are an insurer to the extent of the insolvent insurer's obligations and rights.
I would dispute that, Justice Wendland, and I would point you to the Modernization Act's amendments to this particular part of Chapter 175D. So the statute now reads that MIF shall be deemed, shall have all rights and duties and policy obligations of the insolvent member insurer, which is member insurer is a specific term defined under Chapter 175D. To the extent of its obligation on the covered claims. So I would actually argue, and I think it's clear from the legislature's clarifications recently, that yes, it is the relevant definition of the term insurer, the relevant understanding of that word is derived out of the definitions in Chapter 175D. And Justice Kafker, I would...
Wait, so you're saying a subsequent amendment, that we should be using a subsequent amendment to construe what this statute means?
I don't think that's necessary, Your Honor, because even under the
I'm sorry, I
previous...
misunderstood your argument.
Oh, no, I don't-
You said there
I
was
don't
an
think you misunderstood.
amendment to the statutory language.
Which I think clarifies what was already true. And that is set forth by the General Laws Chapter 175D, Section 1 states that as used as in this chapter, the following terms shall have the following understanding, the usual language that the legislature uses. And it states that it gives a definition of the term insurer that MIF does not meet, but then later in Section 5 says, MIF shall be deemed the insurer, which is a term defined under General Laws Chapter 175D, and where it is stated very clearly in Section 1 that for the purposes of this chapter, that shall be the understanding of the term, and shall have the rights, duties, and policy obligations, it now says, of the insolvent insurer to such extent. Justice Kafker, I want to return quickly to your point because...
I'll leave Justice Wendland until you've answered her question. Are you okay?
I think I understand the argument you've made.
Thank you, Justice Wendland. Justice Kafker, I think that, as this court knows, this is not the first case in which differing definitions of an identical term in different statutes, including the workers' comp statute, have come before this court, and this court has been asked to sort them out. I think your opinion in Camargo's case might be instructive for this court, and that also involved the workers' comp statutes and the definitions therein, in that case, the term employee. And I would direct the court to Camargo's case for the proposition that, absent a more specific terminology from the legislature stating that one definition in one statute is to override a conflicting definition in another, that it has to be the language of...
We can go back to Camargo, but let me take you, because Camargo's dealing with employee versus independent contractor right, which is incredibly convoluted. But this, tell me why this makes any sense not to interpret this the way he says, because I don't understand, I mean, you're going to argue, I assume, the next case too, but...
I'm not, Your Honor. That would be my colleague, Mr.
So I don't, they're paying the benefits. They're paying the COLA benefits as if they were the insurer, because they're stepping into the shoes. Why would it make sense to cut them off? I mean, if it's a pure statutory argument, we'll go back and see if you're right versus he is right. But is there any reason why the legislature would not, because I don't believe the DIA adopted your statutory interpretation of the second part. They do the opposite. They say they do step in the shoes, but they have this argument that he's going to do in the next case, which is if you're an insurer and you're not cooperating, you're out of luck. And we're not going to give these people better treatment than the insurers who are not cooperating. So they don't adopt your statutory interpretation. They do the opposite, but then they have this sort of policy argument about you're not cooperating. But again, I don't see what you're not doing that you're supposed to do for the Workers' Comp Trust Fund. What are they not doing? I just don't get it in terms of keeping the financial integrity of the Workers' Comp Trust Fund. Because I understand how important that is, and I understand how dicey that is, and I understand why the DIA is super concerned about that. It pays for the DIA. It pays for the employers who don't pay their insurance comp rates. But the employers pay for it all, so I don't get it. Tell me why, from a logical perspective, this makes any sense.
Thank you, Your Honor. I think there's a lot embedded to that, so I just want to make sure that I understand and that I break apart your question a little bit. So
Go ahead.
first, I would
put too many
dispute.
thoughts in, but
I would dispute that the DIA is taking the opinion that MIF is an insurer under the workers' comp statute.
I think doesn't the Koziel decision for the board say that you step into the shoes of the insurer? We agree with that, or am I misreading that?
I would say that the reviewing board's decision and the administrative judge's decision previously, which was affirmed by the reviewing board, they both state that under the plain language of the statute, MIF is not an insurer. And in fact,
An insurer, but because of course they're not an insurer, they're the fund, but they step into the shoes of the insurer.
so for this purpose, Justice Kafka, I would say that I think that my brother respectfully misstates the reviewing board's decision a little bit. I would say that Justice Koziel, the reviewing board's decision states that even assuming arguendo that he were correct, it would make no difference because of the second argument, that you'll be hearing later from, and I'm happy to address. But just to make that clear, yes, the DIA's view in this case is that no, under the plain language of Chapter 152, Section 1, the Insolvency Fund is not an insurer. The Insolvency Fund has raised the question of whether it is deemed an insurer and whether that language in Chapter 175D can be imported into Chapter 152. And I think the answer is that even if it were, it would have made no difference to the reviewing board.
Right, because they say because insurers don't get to collect.
Right.
But so again, my question is, why would it make sense to hold this MIF fund, or whatever it's called? They're responsible for paying the COLAs, but they can't get money out of the fund because they're not acting as a conduit. It doesn't have any effect on the workers' compensation trust fund, does it?
So that, I would disagree with that, Your Honor, and here is why. So first of all, I think actually the parties are united on the idea that tying the right to reimbursement to an employer's payment of the assessments is, irrespective of what the insurer is doing, is a poor idea. And that is, to your point, Justice Caput, really goes to the administrability. With respect to COLA, we're talking about businesses that were in business 40 years ago for the bulk. I mean, over the course of 30 years, 80% of employers in the Commonwealth go out of business or change their names or are taken over by other companies. So it would be a nightmare. To be honest, it would be, for purposes of COLA reimbursement, probably greatly beneficial for the trust fund because our...
A nightmare to manage 89 claims, that are shrinking over time. I mean, that's a nightmare. And that they don't change year to year. These people got injured in 1966 or something. I just don't get why that's such an administrative difficulty.
Your Honor, I think that the challenges of tracking what has happened to an employer, whether they're still paying in the funds, whether they're still operating in the Commonwealth, even in a small number of cases, could be extremely difficult. But it would be, for the trust funds, for what the trust fund pays out, I think it would probably be a net gain. But I think it would be very, very difficult for the system.
Can I ask you a couple of questions that I'm hoping will be just factual? The employee here, Burgess, before American Mutual became insolvent, American Mutual was paying COLA payment, was paying out the COLA payments to him, is that correct?
That is my understanding, yes.
Okay, and the trust fund was reimbursing them, is that also correct?
That is also my understanding.
And to whom were those reimbursements made?
The reimbursements are made to the insurer, and then I believe
To American Mutual. And then American Mutual becomes insolvent, is that correct?
Yes, Your Honor.
And MIF has the obligation to cover, has a statutory obligation to sort of step into the insolvent insurer's shoes, correct?
To the extent of its obligations on the covered claims, which are established by the relevant insurance policies.
Right. And so I take it that by virtue of the insolvency, the trust fund's position is that it no longer needs to reimburse COLA, even though the insurer, MIF, is required to continue to pay out on American Mutual's COLA obligation.
That is correct, Your Honor.
Okay,
And that
so
is,
do we have any authority for the notion that MIF, because this is all in part statutory, but in part contractual under the policy.
absolutely, Your Honor.
I take it that your position would not be that MIF gets to pick and choose which obligations and rights it has under the policy itself. Like it
That's
couldn't.
correct, Your Honor.
You're right. Where does its obligation for paying the COLA payments come from? Partly from the policy, I presume, and partly from any place else?
Yes, Your Honor. The policy incorporates, the legislature can establish what an insurer and an insured may agree to in a contract. It may require that an insurer provide certain benefits, and that, but what,
So we've said
without a policy, there is no obligation.
Right, so we've said a million times that basically you get what you contracted for when you entered into the insurance policy, right? And at the time these insurance policies were entered into, because, right, the premium for that policy is set based on what the insurer reasonably expects and the insured reasonably expects will be covered by the policy. At that time, part of that reasonable expectation was reimbursement from the trust fund when it was entered into by American Mutual. Am I missing something in there?
No, Your Honor.
Okay, so how does that change simply by virtue of the fact that the the insurer then becomes insolvent?
I think that that goes to why the rights, duties, and policy obligations of the insolvent insurer language is in the statute in the first place, because MIF is not the legal successor to an insurance policy. It doesn't assume directly, by contract, those contractual rights or obligations or duties. And so that's what Chapter 175D does.
If it
states-
stopped paying the COLA payments, what would happen?
If MIF were to stop making COLA payments under the I think it is not required to make COLA payments by the statute. It's required to make COLA payments by its own governing statute, which imposes upon MIF the obligations that are set forth by the implied
I
or
mean,
express language of an insurance policy.
if
sorry.
MIF stopped paying Mr. Burgess would have a claim,
Yes,
contractual and statutory, against MIF.
I think it would be a contractual claim, but it would be.
Well, no, because there's no contract between him and MIF.
That's true.
Right. So it would be both contractual and statutory.
Okay, Your Honor. So, yes, I think that's correct. But I don't know if there's a follow-up question to that. But Justice Caffer, I do want to get back to one of the questions that you raised before, which is why it matters. And part of that is because the assessment base that the trust fund has, the assessment rate that it sets, where insurers go back to employers and they say, this is what you're going to pay, that is set according to what is reported, the loss experience that is reported to the trust fund. And so if there are loss experiences that are not being reported because a separate entity that is not an insurer, that is not bound by all the terms and conditions of Chapter 152, is not reporting loss experience, that is itself a problem, because then the assessment rate that is being imposed upon employers is inaccurate. They may have to do mid-year assessments that are...
But again, that's to determine the amount to put into the thing, right?
Correct.
The amount that's going out is consistent, right? Because we've got these same 89 people year after year getting paid, right? So the amount that you have to figure out going in is based on the total amount of insurance sold and your rate and your percentage of that total amount of workers' compensation insurance, right?
Well, Your Honor, yes, but I would say, and I know that my time has expired, but...
And you and I are probably the only ones interested in this part of this, but that's okay.
Well, actually,
Yeah.
are you about to say something you've already said?
No, Your Honor.
Okay.
I was going to say that, this case is not simply about COLA, in a sense, because returning to the statutory argument, if this court were to override the plain language in General Laws, Chapter 152, Sections 1, 34B, and 65, and hold that MIF is an insurer, notwithstanding the statutory definition, that goes well beyond COLA and could open up MIF to seek second injury insurance reimbursements.
So if we said they were insurer for these purposes, that would be okay?
I would disagree with that, Your Honor. But I merely want to make the point that, broadly speaking, this is not simply about the 89 cases. It is about, assuming that the legislature meant what it said when it enacted the statutory definition in Chapter 152. And that could affect, if the floodgates are opened, it could affect other claims for reimbursement by MIF. It could affect what reinsurers or excess insurers try to seek under the statute. And so I would conclude by saying that I think this starts and ends with the plain definition of the term insurer as far as the workers' comp statute goes.